Workers' Compensation, Chapter 6 is another chapter that is organized like we talked about before. There's a summary at the beginning of the chapter, and then there's going to be Chapter 440, the actual word-for-word law in the back. Okay? There's not a whole lot of extra stuff like rules and what have you here. It's just pretty straightforward. So, we start out on page 6-5, when is workers' compensation needed? Okay, the first paragraph under when is workers' compensation needed. The Florida's Workers' Compensation Act is applicable to an employer in the construction industry who employs one or more full or part-time employees. Sole proprietors, partners, and corporate officers are considered employees. Construction limited liability company members are considered corporate officers. Okay? And it talks about the next paragraph. It does mention Chapter 440, which is the actual law. It gives a little definition right now. There are some classifications that are exempt on page 6-6. These occupations are exempt. Okay, so homeowner building, working on their own premises, land clearing for appearance purposes, landscaping for existing buildings, fencing, carpet laying in existing. So all these things, well drilling on land containing existing buildings, they make a distinction and they say, well, these classifications, these activities are exempt from the workers' comp laws. Okay. So, we talk about, on page 6-9, self-insurance pools or funds. So, you can be exempt. You don't have to carry workers' comp if you self-insure. This concept allows for, I'm on page 6-9, self-insurance pools or funds. This concept allows for a group of employers pledging their individual assets to collectively guard against exposure for paying workers' compensation benefits. Such pools were very popular in the 80s and early 90s in Florida when insurance carriers refused to write insurance policies for workers' comp and its rates increased. Many funds were connected with certain types of industries, and therefore there is a community of interest of the employers within the fund. Okay. All right. Others. Okay, so that's good. You also have, then the next paragraph, self-insured. Certain individual employers may choose to insure themselves as individual freestanding self-insured. This concept is controlled by the Department of Labor. Allows for employers to provide workers' comp coverage by individually paying benefits. Because of high security requirements and the need to obtain excess insurance coverage, this plan for coverage is ordinarily utilized by the larger employer with significant capital. I had a lady in a class one time who was worked for Baptist Hospital in Jacksonville, and she said that Baptist Hospital was a self-insured. So basically, if you own a hospital, then you can be self-insured under workers' comp. Otherwise, you need to buy.
They have a self-insurance fund in Alabama.
No, do they?
For home builders.
Yep. What happens? 6-10, failure to obtain workers' compensation insurance. In such an instance, the injured worker, the injured employee can require you to pay workers' comp benefits individual or can sue you in court. Suit is filed, you cannot defend the claim basis on the injured employee's injuries were caused by himself or a fellow employee. In addition, next paragraph, workers' comp coverage is mandatory. Florida Division of Workers' Comp can close your business down if there is no coverage, whether or not an accident occurs. It's a misdemeanor of the second degree not to have the required coverage. You can lose your license, it says in the next, for not having coverage. Okay. Employer responsibilities before the accident. Talks about having a safety program, the last sentence of that first paragraph. Okay, let's see. And then on bottom of page 6-11, responsibilities after the accident. The employee should also be advised of the employer's expected safety rules, knowing refusal. Okay. there can possibly be a 25% reduction, and never heard that happening. Employees' workers' comp benefits of accident does in fact occur. Injured worker has 30 days in which... Okay, now that's what's important right here. The last sentence. The injured worker has 30 days in which to advise the employer of the fact that an accident has occurred.
What page?
That's the bottom of page 6-11. Last sentence on the page. Okay, now following the accident, top of page 6-12, once an accident does in fact occur, the employer should be aware of what action should be taken. There are some very definite procedures. Fail to follow these steps, yada yada. Next paragraph, first aid cases requiring treatment that don't disable the employee for more than 7 days do not need to be reported. Next paragraph says, it should be noted, however, that the accident has to be recorded on a notice of injury. If the case later meets the reporting requirements, the notice of injury must be filed within 7 days after the employer has knowledge. So it's 7 days is you have to the employer has to notify the carrier. Okay. Page 6-15 talks about the financial impact of workers' compensation on the contractor. All right. And it says, if we go down 1, 2, 3, 4, 5, 6 paragraphs, employers are classified by their types of jobs, and they are what they call manually rated per $100 of payroll. It says roofers classification is 5551. As of 1/1/16, their premium is $18.60 per $100. I can't believe that at all. I thought it was closer to like $40 per $100 of payroll for roofers. But accordingly, if this employer has a payroll of $100,000, his manually determined premium would be $18,600. Okay. So the second to the last paragraph on the page says your comparison to other employers within your industry is known as your experience mod factor. So if you have had, accidents, if there's been payouts on workers' comp, then your experience mod can go up. Okay. And that means that you're going to pay more than your competitors with better experience mods. Okay. And it kind of gives you an example of the next several paragraphs. We don't really need to go into that. So that's a summary. That's that attorney's summary of workers' comp. Now there's some little handouts starting on page 6-17 that are actually kind of important. There's lots of good little information on these handouts. Okay. Now you can, let's read this. Now we talked about exempt classifications, and sometimes people get confused about exempt classifications of work versus people that can be exempt from workers' comp. Because a lot of times somebody that owns the company, if it's a small company, they'll just choose to be exempt from workers' comp. And that's a valid exemption. Okay, it's different than exempt classifications though. So it says the Division of Workers' Comp offers an online system for applicants to apply for or renew a certificate of election to be exempt from Florida Workers' Comp, or modify an exemption application or print their certificate. Anytime you need assistance, yada yada, it's got all that stuff. So if it's a corporation, okay, corporation must be registered in Florida. And what's important is, third bullet, the applicant must attest to a minimum of 10% ownership of the corporation. So for somebody to be exempt, if it's a corporation, they have to own 10%. No more than 3 officers of a corporation, okay, can be exempt, and it's a $50 fee. And if you look under LLC, it looks like it's basically the same. Okay. So there's your exemption. So there's a little handout there. And then there's another frequently asked questions on page 6-23. These little handouts are really good nuggets of information. Okay. Let's see. 6-24 at the top, they talk about an out-of-state employer, okay, and what you have to know. I'm not going to read it there, but if you get a question about an out-of-state employer and so forth. How about the second paragraph on page 6-26? Does the injured worker pay any part of the workers' compensation insurance premiums? Absolutely not. Okay, it's the employer's responsibility to pay the entire premium. You cannot ask your employees to participate in any payments. Injuries. No, it's got the form. They can ask you about this form, this DWC-1. Injuries covered, injuries not covered, 626 at the bottom. Top of 6-27, a lot of other types of compensation that will not be covered if the injury is caused by the employee's willful intention to injure himself or another. Okay, and compensation will not be paid. Drug-free work, bottom page 6-28, there's a discussion about a drug-free workplace, and you can get a 5% premium credit if you have a drug-free workplace. And some interesting information about those drug tests over the next page or so. Okay, another frequently asked questions. Now this is the injured worker, 6-31. Injured worker frequently asked questions. Okay, how long after an accident do I have to report to my employer and so on and so forth? Well, they don't give you the answers here. They just give you some questions and then they answer them as we go through. So
I follow the answers. How long is an accident? How long after an accident I report it? 30 days.
At the yeah.
My employer reports the injury.
That's right. They're at the bottom. They're on page. They start at the bottom on page 6-31. So they have 30 days. The employee has 30 days to report it to you, the employer. Okay. The employer has to report it no later than 7 days after knowledge. The insurance company must send you informational brochure within 3 days. Okay, so that's for the employee. Who do you contact if the employer will not report an injury? Okay, that's okay. Now, right in the middle of the page, just below the middle of the page on page 6-32, will I be paid if I lose time from work? You're not paid for the first 7 days. However, if your loss time because of your disability extends over 21, you may be paid for the first 7 days. How much?
That's a good question.
Yeah. How much will I be paid? In most cases, your benefit check will be 66 2/3% of your average weekly wage. Okay. When will I get my first check on page 6-33? 21 days after reporting your injury to your employer. Okay. So there you go. Lots of questions. That's employee. I just see where a lot of questions are come from that. Page 6-41. There's another little just informational page here. Coverage requirements, construction industry. It says once again 1 or more employees. Non-construction, it's 4 or more employees. Once again, there's information about your out-of-state employers. Okay. All right. Workers' comp. Okay. 6-59. I don't know why they just kind of have these little almost like little handouts here. 6-59. Is this a different?
656.
It's 656, which says enforcement on it. So it gets to be a little bit different as we go to the as we start getting in the back of the chapter. So 659 in the 2021, 656 in the 2017. When an employer, second paragraph, is operating without coverage, civil enforcement is taken. This most often results in a stop work order requiring that the business of all operations complies and pays a penalty. The penalty is equal to 2 times the amount the employer would have paid in manual premium with the preceding 2-year period, within the preceding 2-year period. Its stop work order may also be issued if they understate or concedes payroll, misrepresents, conceals employees' duties, or otherwise attempts to avoid paying the proper amount of premium. Okay. Fatality reporting, 6-60. Okay, 6-60, fatality reporting. You have to notify within 24 hours is for workers' comp. Okay, so that's a different requirement than the OSHA requirement, so be aware of that. Workers' comp is 24 hours. Okay. All right, so as I mentioned before, on page 6-60, let's see, 6-65, we're talking about the beginning of the actual law. Boom, where are you at? 6-65? Well, we're back to the same page here. Okay, great. Okay, so we go to 6- now we're going to go, this is going to be different. We're going to start being different here. That's all right. 6-65, so that's the same. 2021 and 2017 are the same there. But they're going to start being different when it comes to the word-for-word law. Okay, so once again, 6-66 is our table of contents for Chapter 440. All right. And as we flip through, we've got some definitions. This is the word-for-word law. Just kind of look through these headings. You can see we've talked about some of these things already. There's something in here about this drug-free workplace program requirements.
44102.
Say again?
44102, the drug-free workplace program requirements.
Yes. What page? I'm on page 6-79. 440.102, and the 2017 is what page, you think? Somebody see if I can find 440.102.
.102, 6-79.
There it is. What page you got there? 6-94. Okay. So in here somewhere is a requirement that you have to give the employees, if you're going to start a drug testing program, you have to give them 60 days notice. Here it is right here. Go a couple pages. It's going to be paragraph 12B. So what page is paragraph 12B on?
681.
Yep.
698.
698. Okay. And 698 in the 2017, 681 in the 2021. An employer not having a drug testing program shall ensure that at least 60 days elapse between a general one-time notice to all employees that a drug testing program is being implemented and the beginning of actual drug testing. Give them 60 days. There you go. There's an interesting little bit of information that you may be responsible for, which is 440.104. I'm on page 6-85 in the 2021, 440.104. See if you can find that. 440.104. Anybody with the 2017 got a page number on that one? 107, 6-107 in the 2017. 6-85 and the 2020. So this is kind of a funny little law. If a competitor of yours outbids you and gets a job, and you know that the reason they got the job is because they don't have workers' comp, okay, you can actually sue them for damages, all right? And it says, paragraph number 3, upon establishing that the winning bidder knew or should have known of the violation, the person shall recover as liquidated damages 30% of the total amount of the bid on the contract, okay, or $15,000, whichever is greater. Okay, so it's just kind of a curious little thing there that I would just always found that I would expect that to possibly be an issue. Okay, here we go. Okay, so remember to use that table of contents at the beginning of the workers' compensation section. That's going to help you find stuff that you didn't find in the word for word, in the summary, and what have you. And so there you go. That's Chapter 6, Workers' Comp.